Good morning, everyone, and welcome to today's webinar, Practical Steps to Help Your Business Weather the Insolvency Storm. Fantastic to see everyone online today. My name is Brendan Noney. I'm the President of Western Sydney Business Connection. Before we begin, I acknowledge that I am hosting and recording this webinar from the lands of the Bidjigal people, a clan of the Darug people. I also acknowledge the traditional custodians of the various lands on which you all work today and the Aboriginal and Torres Strait Islander people participating in this webinar. I'd like to thank our webinar supporter, Matthew's Folbigg lawyers, who have been a long-standing member of, in fact, the longest-standing member of WSBC as a Platinum Partner. I'd also like to acknowledge the continued support of our existing Platinum partners, Campbelltown City Council, City of Parramatta, Commonwealth Bank, Hitachi, KPMG Australia, Matthews Folbigg Lawyers, MySkills Australia, NEC, NICAS Australia, Parramatta Leagues Club, and World Class Teams. Our webinar today, Practical Steps to Help Your Business Weather the Insolvency Storm, will be presented by Brown and Stephen Mullette. Jeff is the Chairman of Matthews Folbigg Lawyers and Principal in the Debt Recovery, Insolvency and Restructuring Group, and has extensive experience in voluntary administrations, liquidations, receiverships, statutory demands for payment of debt, applications to set aside statutory demands, informal and formal corporate restructures, including those by way of deed of company arrangement, and personal insolvency matters, including bankruptcy. Jeff is a member of the Commercial Litigation Advisory Committee for the Law Society Specialist Accreditation Program, and presenting with Jeff is Stephen Mullette. Stephen is a principal in Matthews Folbigg Insolvency, Restructuring and Debt Recovery Group and is recommended in Doyle's leading insolvency and restructuring lawyers, New South Wales 2019 to 2022, and has extensive experience in all forms of both corporate and personal insolvency, including bankruptcy, liquidations, voluntary administrations, receiverships, as well as informal and formal finance restructuring. He regularly advises and represents insolvency practitioners and also personal and corporate creditors and debtors in relation to insolvency and restructuring matters. Stephen regularly appears in the federal, family and state Supreme Courts on behalf of insolvency practitioners in respective legal issues involved with insolvency administrations, including trust and property disputes and the recovery of avoidable transactions under the Bankruptcy and Corporations Acts. Stephen is a member of the Australian Restructuring, Insolvency and Turnaround Association, a member of the Law Council of Australia Business Law Section, Insolvency and Reconstruction Law Committee, a member of the Australian Institute of Credit Management and a Law Society accredited specialist in commercial litigation specialising in insolvency. Before I hand over to our presenters, this webinar is being recorded, so no need to panic if you miss something. We'll have time at the end for questions and answers, so pop your questions in the Q&A box and we'll deal with them at that time. So now, to continue on, I'm going to hand over to you, Jeff. Thanks very much, Jeff.
Well, thank you very much, Brendan, and thank you to you and to the rest of the connection for the opportunity today to speak with you about, I guess, a grab bag of issues that have occurred to Stephen and I as being very important to successful businesses throughout this country. We've called this presentation When the Levee Breaks, and you will find that throughout we've managed to keep that nautical theme. At the risk of stretching the analogy to breaking point, I just wanted to stress that the presentation is very much designed not so much for those that find themselves swept up in the torrent when the levee does break, but those businesses that are watching the process from the banks of the swollen river and seeing their customers, their clients and perhaps their debtors being swept out to sea. In other words, there's more out of this presentation, we hope, to be gained by successful businesses, strong businesses, businesses that are well placed to deal with the challenges of 2022 and 2023 than those that are experiencing insolvency issues. So hopefully for each of you watching this today and later the recording, there's something in it for you. Because it is a very broad-ranging presentation, we expect that with each individual, different things that we outlined today will resonate differently. For that reason, and as part of a product offering that Matthews Folbigg, as a platinum partner, is extending to all attendees to the webinar, and in fact all viewers of the webinar, is a broad-ranging offer to consult with you if any of these issues, or indeed any other legal issues, occur to you as needing a review by a legal practitioner. We are quite prepared to sit down with you formally or informally for an initial consultation and document review without charge or obligation. It's a chance to clear the air in a confidential manner and at least get some sort of a roadmap as to how you might be able to deal with whatever challenges this presentation or legal issues generally create. So I'd encourage you to keep that in mind. And hopefully, as I say, as we journey through the presentation, there are a number of topics of interest to you. Can I now hand over to my colleague, Stephen Mullette? We're going to be tic-tacking this presentation. Stephen will deal with some of the broad technical and other issues that have resulted, but I think you'll be starting with where are we now? What is going on with the economy, and what do we, from our point of view, see as some of the major issues? So I'll now hand over to Stephen to get us started, and I'll see you again towards the end of the webinar. Thank you.
Thanks, Jeff, and thanks everyone for joining us. Thanks to Brendan for the kind introduction, and also to WSBC for the opportunity to host this event and talk to you about all things insolvency, which is a passion of Jeff and mine. As you can see, we've called this session "When the Levee Breaks," the insolvency flood that everyone keeps talking about that's supposed to be arriving. And it's been funny over the last couple of years during the pandemic, as you bump into people and or Zoom into people and tell them that you're an insolvency lawyer, everyone was saying, well, you guys must be absolutely flat chat at the moment. And of course, it was quite the opposite. And for a couple of different reasons, primarily a lot of government incentives that were keeping businesses afloat, obviously, and also a lot of forbearance, both from the corporate sector. A lot of the banks didn't want to be seen to be the bad guys squashing small business in the middle of a global pandemic, but also from a government perspective, the ATO going quietly in relation to a lot of tax recoveries, and the ATO being the prime mover in all things debt recovery, insolvency related, being the major protagonist in the federal court and Supreme Court corporations lists. It stepping out of the picture meant that there was a very quiet period for insolvency practitioners during the COVID pandemic. So much so that, in fact, a significant number of insolvency practitioners themselves in smaller firms, in smaller debt recovery firms, were on JobKeeper and themselves needing assistance from the government to keep the doors open. But what that's also led to is an impending sense of financial doom in the economy. And as we gradually wind back on both incentives and as the pedal comes off the brakes in terms of debt recovery and the enforcement of financial obligations ramping up, what we have been anticipating is that all that debt that was gradually accumulating during COVID is going to come out in either a broken levee, or alternatively, the other really common metaphor is the insolvency tsunami that everyone keeps talking about. And this is the pool of companies that have been struggling along during the pandemic, picking up on financial incentives, taking advantage of tax office leniency, and gradually clinging to life. But at the end of the day, the chickens will come home to roost, and the insolvency wave will collapse, the levee will break. And from an insolvency practitioner perspective, I think everyone's anticipating that the tsunami will be a financial boonful for insolvency practitioners. I actually don't think that's going to be the case, and most insolvency practitioners in reality have some grave doubts about what's going to be left in a lot of these companies for reasons that we'll come in and have a look at. So that's the general theme for today and the context in which we wanted to talk to you all about the things that we see happening. What we're going to cover is just a brief look at some numbers and some trends as we see them. We're lawyers, not accountants, so take them with a grain of salt. This is just how we see the statistics picking up. Secondly, we'll look briefly at a couple of external administration issues, just a refresher on terminology, but also a couple of new forms of external administration. Thirdly, we'll look at some things to expect that are going on behind the scenes with your customers and your clients that you may not necessarily be aware of. They might be affecting you as well, but they're certainly affecting the broader economy as the brakes come off and the debt recovery processes start to pick up. And then lastly, Jeff will take us through some tips and tools to help us work our way through this next period of the financial recovery. So starting off with just a quick overlook at some numbers and some trends, probably one of the key factors and the key drivers in terms of that financial moratorium during the COVID pandemic was actually government enforced. So the beginning of the COVID pandemic, way back in March 2020, the government introduced a whole package, an omnibus bill of reforms that were designed to alleviate the financial crush that was expected to eventuate if the government didn't step in and take control of things. And critically in the debt recovery space, what it did was this: it increased the thresholds for 6 months for the main two sources of insolvency activity on a corporate space and in the personal insolvency space. On the corporate side, creditors' statutory demands were increased in their threshold up to $20,000, and similarly in the personal space, personal insolvency bankruptcy notices, the threshold for being able to issue a bankruptcy notice was increased up to $20,000. Secondly, the time to comply with those notices, which is normally 21 days, they're normally designed to be a quick means of putting significant financial pressure to encourage debtors to pay their debts, was extended from 21 days up to 6 months. So basically it ripped the guts out of that sort of space in terms of debt recovery, removed the ability of those creditors that actually did want to actually actively chase their debts, putting to one side the ones that were in a sense voluntarily not wanting to make it difficult for their customers during the pandemic, but financially put a significant roadblock in the way of those debts being enforced using those sort of techniques. So that period was for 6 months. It expired at the end of, or towards the end of September 2020, but then was extended for a further 3 months. What it also coincided with was the government looking at those thresholds in any event, which is a process that had started prior to COVID. So as that moratorium was lifted, there was an increase in the threshold in creditors' statutory demands anyway from $2,000 to $4,000, and in bankruptcy notices from $5,000 to $10,000. So whilst the $20,000 limit has come off, there's still been an increased threshold, which has had a significant impact in terms of debt recovery generally. What we are, though, is back to the 21 days for compliance with those reforms. So those two numbers, those bankruptcy notices, those creditors' statutory demands, had a particular impact during the first year of COVID, and we're really starting only to see the impact of those changes sort of coming off in the second part of this year. Just in terms of some statistics, these are just publicly available statistics. On the personal insolvency side, what you can see there is the last 14 years of insolvency activity in the personal space, so bankruptcy. As you can see, there's a general trend. There has been a general trend for many years in terms of decreasing personal insolvency. And obviously that was tipped off significantly in the last couple of years during the COVID pandemic. On the personal insolvency front, again, you can see in that activity over the last 3 years that the period up to the beginning of this year and also last year was significantly below the 2020 year. And even that, as we saw from the slide before, was trending downwards as well. So a massive shortfall or under recognition of the amount of personal insolvency activity that might be expected during the middle of the pandemic. On the corporate side, this is a statistic showing the trends over the last couple of years in the corporate space. Again, trending in 2022 financial year, significantly below the previous year, and also at historically low levels. What we've also seen, though, this is up until sort of the April year, is that since around about April, the trends have been markedly different, trending back upwards. And particularly once you start to take it by industries, the construction industry is a pretty good bellwether for the commercial economy as a general proposition. And in the first part of in the 2021-2022 years, we've seen a significant increase, and you would have seen a lot of that press in terms of the collapses of building companies, construction companies increasing significantly and affecting a lot of first-home buyers and project developments. What we've also seen in the corporate space is that there's that significant deduction sort of over the past 5 years. You can see the massive drop during the global pandemic, and also that start to trend upwards in terms of external appointments to corporations. And we come then to this slide, which is the most recent statistics, came out a couple of weeks ago. Again, sort of up and down, so not necessarily stable, but much higher and much more along the lines of the benchmark activity pre-COVID. So we're in that space where there's still a lot of uncertainty, there's still a lot of delays in enforcement and so on and so forth. However, trends significantly higher in terms of external appointments for corporations. Two things to bear in mind in relation to that slide there. These are statistics that are, without the ATO, getting actively back in the game in terms of corporate enforcement and personal insolvency enforcement activity. As lawyers, we keep an eye on the court lists, and the ATO is the primary mover, the primary creditor in the personal insolvency corporate space, and they are the largest number of winding up applications by the ATO, and they haven't really entered the lists yet. So although we'll come to some information later on, which will talk about what the ATO is doing, at the moment, they haven't got to the point where they are back to their pre-COVID levels, being the major winding up plaintiff in Australia. So that's one thing to bear in mind. Where these trends are already increasing, there's a lot more hurt to come, is what that tells me. Secondly, the other thing that I think people need to be aware of, and it was confirmed in an article I read yesterday, which is that this is at a time when there are historically large numbers of deregistrations of companies compared to formal external appointments. Now, you've got to take that with a grain of salt, given you're not necessarily comparing apples with apples, but these are where companies just end up being deregistered rather than being formally wound up by the controllers or by creditors. Historically, that's been tracking at around about 5 times the number of formal external appointments. As of last year, I think it's around about 13 times. So there is a significantly higher number of companies that are just being deregistered, not necessarily being formally wound up. What does that tell us? Well, there's probably a few things you can take from that, but I think it's telling us a little bit about these statistics, not necessarily being all that there is to say about how the insolvency trends are tracking. So with that in mind, just a couple of things on external administration formally. By way of a background, just in terms of the difference between personal and corporate, just so that we're all speaking the same language, and so you can all correct the media when they get it wrong and talk about the wrong terminology. In the personal insolvency space, what we're talking about is the Bankruptcy Act primarily. There's a separate piece of legislation for personal insolvency and corporate insolvency. In fact, if you really want to get technical, there's at least 6 pieces of legislation for both personal and corporate insolvency that insolvency practitioners have to grapple with as they administer it. In personal insolvency, you're talking about an individual. Unlike the United States, bankruptcy only means individuals in Australia. you're talking about the registered trustee in bankruptcy or the government trustee, and you're talking about different parts of the Bankruptcy Act. In the corporate space, this is where you have your secured creditor appointments through your receiverships and your receivers. You talk about external administrators as a catch-all term to describe all different types of formal external appointments to companies. The formal voluntary administration regime that we've had for 30 years in Part 5.3a, and we'll come back to the new form in a minute. And corporate insolvency deals with liquidators, liquidations, and so on. So two completely different pieces of legislation, two separate ways of thinking about insolvency, personal and corporate. But during the middle of the pandemic, one of the things the government introduced, which it had been thinking about already, but which I think it fast-tracked in light of what was going on, was small business restructuring. And this was announced sort of in the middle of the pandemic in September 2020 as the most significant reforms to Australia's insolvency framework in 30 years. The aim of it was to give Australia a debtor in possession model, a little bit like the Americans have with their insolvency activity, where the debtor stays in possession and in control of the business whilst they're going through a restructuring. That's the only similarity to the American system. But what the government said with this most significant reforms in 30 years is that they wanted to start it within 3 months. They eventually got round to preparing a draft bill for everyone to consult on. They gave that to us with 5 days to consult, 2 days of which were a weekend. And so you can probably imagine the amount of input that the industry had into these reforms and the amount of recognition that the government gave to the relevant stakeholders. But they were good to their word in the sense that at least it started on 1 January 2021. And what it did, it introduced a new part to the Bankruptcy Act, to the Corporations Act. So instead of Part 5.3a, the formal voluntary administration regime, now we have Part 5.3b, small business restructuring, with that object of allowing businesses to stay in control of their owners whilst they're going through a restructuring plan. The focus is on small businesses, the name might suggest, and what the government defines as being small business might be different to yours and my definition, but it involves less than $1 million of total liabilities when the restructuring begins. The company can't have gone through it before, but otherwise it's open to all businesses with that kind of debt activity. The aim is to appoint a small business restructuring practitioner who at this stage has to be a registered liquidator, to a normal administration organization where they are the independent controller and administrator of the company. In a small business restructuring, the aim is for them to work alongside the company to provide advice to the company to help put together a restructuring plan, whilst also having some sort of oversight on the whole process. The aim was to keep the costs down. You have to be a fixed fee for the plan, before the work done before the plan's put to creditors, and then a percentage of whatever payments are made to creditors under the plan. A lot of similar restraints on the formal insolvency side for companies. You can't transfer shares, winding up applications will be adjourned if the court thinks it's in the company's interests, and court proceedings are stayed, and that includes against directors as well. So a lot of similarities with the more big brother, the voluntary administration regime. And the aim altogether is to get this restructuring plan to get to creditors. It can only be put forward by directors, which is a slight limitation on its flexibility compared to voluntary administration. It's streamlined. It's got to be done within 20 business days, although the restructuring practitioner can extend that for a little bit. And the critical kicker for most people in this insolvency space is this. Before you can submit your plan to creditors, you have to have paid all your employee entitlements up to date, and you have to have lodged all your outstanding tax lodgements in order to qualify for a small business restructuring. Now, it's probably self-evident, but the first thing that small businesses do when they get into financial trouble is A, they stop lodging their tax returns because they stop paying their tax debt, and B, The second people to stop getting paid are the employees in terms of their long-term liabilities. So getting small businesses to a point where they can then spend the money to catch up all those employee entitlements and then spend the money to get their accounts to lodge all their tax returns so that they qualify this restructuring plan, I think has been one of the major impediments to getting more of these restructuring plans together. The plan itself is going to involve payments to creditors, which has to be over a period of less than 5 years, but that's the aim. Keep it simple. Put a proposal to creditors, which they can vote on to give them a return on their debt over a period of less than five years. So once that plan goes out, creditors get 15 business days to vote, and a majority of the value of the external creditors will decide whether that plan gets up or gets down, or gets put down. One problem with the reforms is that if the plan isn't voted in, there's no automatic transition to any kind of formal insolvency appointment. The company just meanders along into the into the horizon until somebody actually takes the activity to wind them up, or they voluntarily put themselves into liquidation or some sort of alternative reforms. Restructuring plans can only be varied by the court. Creditors will rank equally, and the practitioner will hold the monies that the company has to pay towards those plans. Termination if there's a breach, and otherwise that's your basically a simplified deed of company arrangement or voluntary administration regime. The other kind of external administration that the government introduced in the same package was this idea of what they called a simplified liquidation. The primary aim and primary thing you need to know about it is that the intention was, according to the government at least, to reduce the amount of paperwork, reduce the complexity and the cost of simple liquidations. Again, applies to companies where the total liabilities are less than $1 million. And probably the main thing for creditors and companies to be aware of is that it reduced the scope for unfair preference claims by a liquidator to less than $30,000 in the 3 months prior to the liquidation. So not an insignificant change, but probably not as revolutionary as the government wanted to suggest. Reductions in the amount of paperwork, meetings, reports, and those sorts of things, simplified voting processes, that's the aim of this simplified liquidation. What's been the result of all those massive reforms, the biggest reforms in 30 years? Well, it's been particularly slow on the uptake. I think probably because of those significant limitations, having to have all your employee entitlements paid up to date, making sure you can find enough money to get your accountant to lodge all of your returns, having the debts less than $1 million. But look, it's horses for courses. There have been a few, and I think, it's a bit like putting umbrellas on a pair of shoes, or maybe having flippers for high heels. There will be a particular scenario in which that would be very handy to have. And so, look, not ruling out small business restructuring as one of the ways to weather this storm, but at the moment, it's probably a little bit of a white elephant. The government could easily transform it, increase the threshold, remove the obligation to pay employee entitlements and get tax returns up to date, and that would significantly increase the attractiveness of it for a lot of small businesses. So the other thing we wanted to cover is what to expect during this next sort of period, and the primary thing we wanted to have a quick chat about in relation to that is directors' personal liability. So this is to give you an idea of what's going on behind the scenes with your customers, your clients, your suppliers that might impact upon their financial viability during the post-COVID period. Many of you will be aware that basically since 1993, directors have had a personal liability for a company's unpaid PAYG and SGC. Basically, it's a penalty that the government imposes, which is equivalent to the company's liability. And the ATO will issue what they call director penalty notices prior to taking action to recover that debt. In 2012, there was a significant reform that meant if you haven't been keeping your lodgements up to date, those liabilities became locked down. And that meant that even if you got your paperwork up to date, even if you appointed a voluntary administrator, that penalty wasn't waived. When these reforms were introduced, the aim was to encourage people to make appointments. In 2012, that encouragement was significantly reduced because it didn't matter whether you made an appointment of an insolvency practitioner or not. The director was still on the hook. The liability was, as the ATO calls it, locked down. In 2020, so this is again in the middle of a pandemic, whilst the ATO is going very quietly in terms of enforcing debt, whilst the government's pumping money into the economy in the form of incentive and whatever, these reforms introduced a significant increase to the scope of directors' personal liability for a company's tax by adding to the mix of taxes for which directors are personally liable, GST, and a couple of other taxes as well. So now directors, as they continue to trade a company which might be in financial trouble as it comes out of the lockdowns and COVID pandemic, will be sitting there with the ATO having gone quiet on enforcing debt, not waiving debts necessarily. This debt pool has been increasing, and now from at least April 2020, directors have been on the hook for GST as well. So you can probably get the sense that there is a big ATO pool pending. What sort of support has been available during COVID? Well, nothing formal from the ATO, although informally there was just no insolvency activity from the ATO. What they offered was to tailor solutions, and there certainly have been a lot of success stories in the ATO being willing to work during the pandemic in terms of restructuring tax liabilities and reforms. How much that's going to continue is questionable sort of as we go forward from now. And that's because of this. What we've seen in the last couple of months, this is from May, the ATO has announced that it's going to start chasing small business debts as the COVID holiday ends. In May again, 840,000 reminder letters, outstanding 52,000 letters about potential director penalty notices. So these aren't the notices themselves, these are the letters warning about the fact that they might issue a director penalty notices. But it's gradually building, as you can see. The levy can only take so much. And really what it relates to is this, a $33.5 billion tax hole that the ATO is going to have to recover at some stage. How quickly and how efficiently they do that and take the foot off the brake pedal in increasing that debt recovery will have a significant impact both on personal liability for directors with all of those corporate taxes hanging over their heads, and corporate insolvency with the government actually taking activity to enforce those liabilities. So we come to what we can do going forward and weathering the storm. What we've seen in the press is these sorts of headlines, all with a weather-related theme, you know, headwinds buffeting the economy, doom and gloom outlooks, economic storms, perfect storms, and a global recession, headwinds, perfect storms, heavy weather. And Jeff, how are we going to weather this storm?
Right. Well, Stephen, I'm glad you asked. One of the purposes of this presentation is to make sure that none of the attendees are like my two friends here, happily enjoying a cup of coffee while a tempest breaks around them. The environment that Stephen has just described is really one that I think is potentially, although not disastrously, dangerous for solvent and thriving businesses. The danger basically is that there is a lot of economic distress out there that is, for one reason or another, either hidden or easily able to be hidden. So Stephen gave some good examples of things like tax debt and obligations to employees, which are very difficult for an outsider to assess when you're looking at relationships between you and your customers, your clients, and those that you're extending credit to. It's not all bad news, though. There are a number of avenues that have been around for quite some time, and a number of avenues that have only just been implemented or will be implemented that have definitely improved things. So let's start by looking at the government's recent announcement that it will be allowing the ATO to disclose its tax debts to credit reporting bureaus. Up till now, credit reports have been a little bit like my friend here handing in his school report to dad. They are useful documents. In some instances, they're very useful documents, but they never really gave us the unredacted picture. One of the glaring omissions has always been, is the company that I'm about to extend credit to, or that I'm about to enter into a potentially lucrative long-term relationship with, hiding effectively the most serious of its debt, that is a debt to the ATO, in order to produce as positive a picture as possible in terms of its credit history. So in other words, protecting itself from defaults by what I would call non-government based debt, getting its ducks in a line so far as its relations with suppliers and so forth is concerned, all the while allowing a tax debt to build that just can't be made the source of public information. Well, that's, I'm happy to say, likely to very significantly change in the very near future. As Stephen said to you, and the statistics prove it time and time again when we look at individual liquidations, tax debt is usually the last debt that businesses are in a position to pay, or at least make the strategic decision to pay. And the ATO has been historically quite slow to start its recovery action. So in terms of what you can see about the public face of a potential customer, it's often been very easy to shield a fundamental problem. So what's going to happen? Well, the ATO has taken, in my view, a relatively small but nevertheless significant step towards changing all that and disclosing tax debts to what they're calling non-engaging taxpayers. So what they're going to do is they're going to effectively release information about individual corporate taxpayers and personal taxpayers who have failed to pay tax debts over $100,000 that has been outstanding for more than 90 days. Now, in terms of further detail, in order to be what the ATO is considered to be a defaulting taxpayer, you have to have not engaged with them, basically. So in other words, you don't have a payment plan with them, and you haven't taken any other steps to either seek a review of the debt or an exemption from having to pay the debt. One of the things that the credit reporting agencies are a little bit annoyed about is that all that a recalcitrant taxpayer has to do is engage, that is, pick up the phone, speak to the ATO and say, I'm interested in maybe negotiating some sort of payment plan with you to pay this debt. And the tax debt goes from being a disclosure-based debt to a non-disclosure-based debt. In other words, it becomes confidential again. That's a serious limiting factor, and that may be looked at again by the ATO once a few statistics come through as to how much this information is used. Again, there's a fairly cumbersome administrative process where the ATO writes a letter to the recalcitrant taxpayer and says, please pay your tax or engage with us. And then it's only after that has happened that credit reference agencies that have signed up to this scheme are allowed access to the information. At the moment, the three larger credit reference agencies, some of which you may have used or heard about before, Creditor Watch, Equifax and Ilion, have all signed up to this and are enthusiastic proponents of this type of scheme. So watch this space, but I think it will at least to some extent free up some of that information and make these credit reference reports that you can get when you engage with a new customer more meaningful. Another reform that I am excited about is the implementation of director identification numbers. Now, again, some of you may have already been contacted by the government and asked to get involved in this usually online process of having an individual non-transferable permanent number assigned to you if you are a director of a company. What the government is seeking to do is generate a unique identifier, which goes out to you as a director and travels with you for as long as you are a director of any company. The time frame is certainly coming up to being urgent, in that it's anticipated that by about the end of November, the database of director identification numbers will cover pretty much everyone who already is a director, and will cover those that have recently had to apply for a director identification number. So, I mean, why are they so useful? Well, if you do what I think you should do and search this database every time someone applies to your business to be a customer or asks, more importantly, for credit from you in terms of delivery or any other provision of services, a director identification number will show you the history of this individual, what companies they've been a director of. You can cross-reference it against whether any of these companies have been in any sort of external administration, so had an administrator appointed or a liquidator appointed, and generally speaking, the financial health of the companies that they've been responsible for stewarding. That's particularly important if you're going to ask for a personal guarantee from that director, because it will be an indicator as to what their likely worth is going to be. When you combine that with the ability to search for tax defaults under the recent ATO reforms I've just outlined, we're starting to get a kind of a regime for checking credit worthiness, I should say, that has got a bit of teeth to it. Look, that's certainly got the potential to be a terrific reform. One of the oppositions I have seen in the past, particularly with larger clients of our firm who engage almost every day with new entities as customers, is that it is an expensive process to do a company search each time that you bring on board a new customer. Well, it's always been an issue from my point of view that the kind of information that could really protect a business from being swept up in this insolvency storm is contained in paid company searches. Well, from September 2023, at least on current information from the government, creditor searches are going to be free. I love company searches for creditors. I'm a huge fan, and there is so much information contained in those documents that can really, really help you protect yourself from customers that aren't perhaps telling you the full story about their financial position. What it can also do is make sure that your originating documents, your credit application form or your customer identification form that you set up within your system, contains accurate and legally binding information. Quite often we get asked to chase sometimes very, very large debt relating from complex and expensive work, only to find that our client has failed to get correct details of either the customer or the guarantor. It happens a lot more than you would think, and unfortunately it can be fatal to an application to apply more pressure, either by way of legal proceedings or even from demands. So getting all that right is, yes, it can be a little bit boring and administrative, but it is crucially important. The final limb, I suppose, of relatively recent reform is the personal property securities legislation. Now, some of you may well have been at previous seminars that either our firm or other firms have run in relation to the very substantial reforms to this area of law. Some of you may even have stayed asleep for the entire seminar, in which case you have my congratulations. It is a very dry area of the law. It effectively governs the way that the law recognises security that you seek to put over the assets of someone that you would like to do business with, that you'd like to perhaps hire out equipment, or in other ways lose control of either stock or equipment and give it to someone who hasn't paid for it yet. And it governs effectively interests in everything except land. It's undergone some radical reform over the last several years. It remains in a state of reform. What it can do if you do it right, cutting to the chase through all the legal technicalities, is it gets you a seat at the table if your customer goes into liquidation or an individual goes into bankruptcy. It allows you to have a priority for the debt that you're owed over and above anybody who isn't secured. In some cases, it can give you a priority over everyone else who has a priority. So that usually wakes my seminar attendees up because it's something that can get you above and beyond the general unfortunate rabble of creditors who are wondering whether they're going to get 7 cents in the dollar or 9 cents in the dollar or nothing at all. Depressingly, it is often that sort of dynamic. You're either a secured creditor and you have a real shot at recovery of a substantial part, if not all of your debt, or you're an also-ran. So this stuff becomes quite important when we're going into an environment where insolvencies are likely to be on the rise and a lot of fundamental large-scale debt is effectively hidden. So a few fun facts about the PPSR. You don't need the grantor, that's just the legal term for the customer or the applicant for credit. You don't need their permission to register. You just need a valid security. So you just need to go through your terms and conditions to ascertain whether you've actually got a security that's capable of being registered. Quick plug here, we regularly do that kind of work, and it's certainly something that either in the terms you've currently got or with some relatively minor amendments, you can get yourself in a position where you can register. You can, as I say, register to have a priority that survives a liquidation, and to the extent that you may have provided goods on credit, it may even trump the banks, which is always a nice thing to be able to do. You can search the register, and as well as doing a company search, I always recommend it as something you may want to do when you've got a prospective customer or a prospective applicant for credit or supply of goods on credit from you. The PPS search will give you a very good snapshot of who else they've given security to. And if you learn to interpret these forms correctly, it will even help you predict where you may stand in terms of priority if this person goes into some form of external administration. So hopefully this presentation has ended with a glimmer of hope. I hope it's also dispelled some of the misnomers you've got about what everyone seems to be calling the insolvency tsunami. As is always the case, the actual position is a lot more complicated and nuanced than that. But the good news is, for the savvy commercial operator in today's world, there are plenty of opportunities to shore up your position and make sure that you make the most of the economic upswing when it does happen, and that in doing so, you're not inadvertently swept up in some sort of levee break. Now, that's all that Stephen and I had, although, of course, we are very keen to answer any questions you've got, either now or at any time by emailing either one of us. Thank you very much for your time. I'll hand over now for questions to our facilitator. And as I say, thank you for your time.
Thanks very much, Jeff and Stephen. Does anyone have any questions? I haven't, so just pop them in the Q&A panel at the bottom of the screen. I haven't seen any come through at the moment. No questions? I'll give them a little time. But look, this is a very important topic to be on top of, and thanks very much, Jeff and Stephen, for the instruction effectively you've given us to the things we should all look out for. Oh, there's some questions coming through. Are we sharing the presentation slides? I think Cassidy's answering that one.
We're certainly happy to share them.
Okay, there we go. There we go. So yeah, there will be some slides that will be shared by the team at Matthews Folbigg. Are there any further questions? Okay, it doesn't look like there's any coming through. So given that's the case, thanks so much again, Jeff and Stephen, for the presentation during this webinar. And Matthews Folbigg for your ongoing support of WSBC as a platinum partner. It is a very valuable relationship to WSBC, I assure you of that. For further information about membership with WSBC for those that are non-members on this webinar, feel free to reach out to the team or go to wsbc.org.au. Also, on our websites, you'll find a list of upcoming events, including our upcoming webinar with Simone Renix from My Skills Australia on how to create a one-page plan to drive customer decision-making. And don't forget to register for our Business Leader Luncheon held on Wednesday, 19 October, with Simon Kustenmacher, who, if some of you came along to the State of the Region with the Premier back in May, you would have heard from him. He was very, very entertaining. And for someone that does demographics, which is also a fairly dry topic, he makes it very interesting. Registration event details are on our website, so please check it out after this webinar. Once again, thanks, Jeff, Stephen, for your time today. And for everyone that's online, have a great afternoon and enjoy the day. Thanks so much.